the media pertaining to investigations that was undertaken in KwaZulu-Natal. And in this particular specific instance, I'm referring to the investigations that came up in the Madlanga Commission, where initially Lieutenant General Khumalo cited certain cases and convictions and a history or record of a one Mr. Stuart Sharnick. His report and his statements in the Madlanga Commission prompted Mr. Stuart to make certain public statements and announcements. I want to just summarize specifically what he had said in that particular, so we put context to his concerns regarding these cases. In the same evening of that briefing, Mr. Stuart indicated that his convictions runs from 2010 to 2011, and it had 18 counts on one case. If you go back to the clip, you'll realize that he talks about one case with 18 counts. And he indicates that he was sentenced to 5 years suspended sentence, and a portion of money was paid. His sentence was, his suspended sentence has since lapsed, and then there were cases where the state had withdrawn. He had various cases which he had reflected on, but he chose then to talk about the one that was resolved only in the court. On November 12th, Mr. Stuart also went back to the media, and then he made certain pronouncements and accusations or leveled allegations against the institution of the South African Police Service. In part of making such allegations against the South African Police Service by virtue of Lieutenant General Khumalo, who had made those statements in his capacity as the head of crime intelligence. By that virtue, South African Police Service then becomes the bearer of such allegations. And he was quite vocal to indicate he intends to join the current acting minister in the South African Police Service to that particular action he intends to take in the matter. Now, I want to then reflect on a few things. Why would we want to call this particular briefing? For the purpose of record all the cases, whether General Khumalo had referred to it, whether it's Lieutenant General Khumalo had referred to those cases, and the cases that Mr. Stuart Sharnick is referring to, they were cases in terms of that particular conviction that were cases in the province of KwaZulu-Natal. So in that, it came to a point where both parties, Lieutenant General Khumalo as well as Sharnick, was referring to very serious cases of hijacking, theft of motor vehicles. And what comes out is that this matter was somehow settled through a plea where a slap on the wrist was given to somebody. And in the case of Mr. Stuart, he is vehemently denying that he was charged on 18 cases. He says he was charged only on one case with many counts. Now, members of the media, I want to then go into one aspect which compromises the integrity of investigations in the province of KwaZulu-Natal, because it then leaves one to ask the question, if he says it's only one case, what happened to the other cases that were serious charges levels against him? And I want to then go into a breakdown of these cases and indicate to you what we have been undertaking. So as a result, in KwaZulu-Natal, we have then called for the profile of Mr. Stuart. We've looked at it in terms of cases where in KwaZulu-Natal he was a subject of investigation, where he was a alleged suspect in the particular matter. We have physically perused each and every one of those cases, and we've been through every single document in every single case file. I want to highlight a few observations that we have made through this exercise. So the first thing I would want to indicate is that we have looked at 29 criminal case dockets. Where? So you have been listening to a version of 18 counts. You heard a story of 18 counts on one case. I'm going to show you a picture of unpacking 29 cases against this particular individual in the province of KwaZulu-Natal and what types of crimes it relates to. I'm going to then start by indicating firstly that 10 of these 29 dockets where part of that plea was related to theft of motor vehicle. The cover of the docket, the charge, the vehicle involved, it's a vehicle, it's a theft of motor vehicle. 8 of these 29 cases that I'm referring to were cases of carjacking. So cases of carjacking. Now if you know carjacking is slightly different from theft of motor vehicle. In theft of motor vehicle, a car is stolen without interaction in some cases, or there's no interaction with the victim. The car just gets stolen through various means. But when you talk about carjacking, we're talking about a violent crime where force and an extent and a level of aggressive emotion and actions are taken against victims. Now these were 8 such cases. So that gives you a total of 18 cases. So if you understand what we spoke about earlier, Mr. Stewart talks about 18 counts on one case. There are 18 case dockets, a combination of hijackings and theft of motor vehicle that we are talking about. These dockets at the time of investigation we did not see how it ended up into being centralized, but it became centralized to the Serious Organized Crime Unit within the Directorate of Priority Investigations. This is purely from looking at the physical docket before us. We're not talking about anybody making a statement somewhere. We're talking about a physical inspection of every docket. These dockets come from all over KwaZulu-Natal. And members of the media and the public, I will start to cite some of these dockets specifically related to theft of motor vehicles and hijackings. One of such matter was in the Durban Central area, which is a theft of motor vehicle. So, in the theft of motor vehicle, it took place where the complainant confirms in his A1 affidavit that his car was stolen from him. We have the details of who the investigating officer, as I said, it was centralized. This is one of those dockets, and it was pulled together with the other dockets. The next case was in Hillcrest. It was a carjacking. This case of carjacking, he was also charged for, and it forms part of the plea agreement that was signed at court. The next case that I will refer to is the case of theft of motor vehicle from Durban North. The following case is a case of carjacking, again at Chatsworth. The next one is a case of carjacking in Westville. We have another case of carjacking in Newlands East. We have a theft of motor vehicle in Townhill, a carjacking again in Sydenham, a carjacking in Pinetown, a theft of motor vehicle in Durban North, a theft of motor vehicle in Townhill, a carjacking in Malvern. Howick is a theft of motor vehicle. In Maryland is carjacking. In Bratton Beach it's burglary residential. In Richards Bay it's another case, I'm going to come back to that. I will specifically focus on the theft of motor vehicle and a carjacking. Again, another carjacking in, theft of motor vehicle and housebreaking in Mpangeni. Then another theft of motor vehicle in Hillcrest. And we have then another theft of motor vehicle in Maiden Wharf. I will come to the other cases in a short while. What we find in all of these cases to which the plea, so the court will better explain their processes of how they have accepted this plea. For now, we cannot, and I will not attempt to indicate what would have informed the court at that time to enter into a plea of all these serious crimes against this particular accused in court to the fine that he paid. So I'm producing to you, members of the public and media, that there are 18 such dockets. These dockets, when you open these dockets, it is syndicated. If you understand organized crime, it is syndicated. In most of these dockets, Mr. Stewart is the one who had sold these people who had possession of the cars. In some instance, he was in possession of a car. But in majority of the cases, he sold these cars to people. And when you go into these dockets, there are very common actors that facilitate and enable organized crime to take place. From a scrapyard dealer, to a police clearance, to a registration of the vehicle, there's a whole chain involved. So in that docket, there's a lot of compelling evidence that suggests a lot more than what the plea was made out to be. You can ask yourself, if a person is in possession of a stolen property for one hijacked car, what should be an appropriate sentence? What would be, as the National DPP and the DPP will put it, how will justice be served, and what will be in the public's interest for a person who is a victim of carjacking, where the person who played a role in whichever way, whether it's a role of facilitating that hijacking or whether it's a role of receiving stolen property and selling them and creating a market for it, whatever the role, there's trauma in carjackings to the victim. So one will ask, in that particular instance, if you accepted a charge or gave a plea of a lower sentence, such as wholly suspended for 5 years, and now you don't do it for the one case, you put it there as if it is one case in court, but there are 18 criminal case dockets that we are talking about. So in court, these dockets went to court. Like I say, members of the media, I cannot pronounce on what legal position and mandate is undertaken and the process. I cannot prescribe or comment on it. It is something for the NPA to comment on as to how they arrived at that plea for so many of these cases. And you consolidate all these 18 dockets, you call it one case, and you give one sentence of 5 years suspended, and you say there's a fine that you can pay of 150,000 rand over 5 years. I leave that to the NPA, but I'm not making a statement that I'm leaving to the NPA. Following this media briefing, as we've gone and done this analysis, and we've done an in-depth analysis from the time we realized that KZN investigations are coming under the spotlight, we have a fantastic work done. How did it end up in this way? Now, we cannot allow us to just keep quiet and make a media briefing. So we are preparing 2 dossiers. One will go to the Director of Public Prosecutions, where we're highlighting what our findings was. And members of the media, I must tell you that I'm giving you a summary of the findings. I've hinted to you that in the docket we see very clear actors and people in the organized crime part of this vehicle syndicated crimes. So we are referring this to the NPA to review what scope or role or mandate was undertaken by the prosecutor. Did he have that delegation to do that? Was it approved? And those type of things. We also will send a separate dossier to the Magistrate Judicial Commission for them to undertake an exercise to determine whether the magistrate was provided with all the relevant information when he accepted this plea from the accused. So that is a part we will leave for the judicial system. So I think when we talked about the certain aspects that needs to be looked at within the prosecutorial authority as well as the judicial system, it is what has always been played out in the media. I want to then talk and touch on a few other matters that did come up during the press conversations of Mr. Stewart, as well as certain aspects that came out from Lieutenant General Khumalo. But before I go there, I want to then go back. I indicated to you, I'll come back and tell you about the other cases that was leveled against Mr. Stewart in addition to these cases, and how those cases then was resolved. So when you look at the other cases, I want to point out to you the cases that are not vehicle related and the cases that are on other matters. There's one matter that is related to an assault GBH that was committed, and in this particular offense there was a fine of 3 months or imprisonment of 3,000 rand. There's another matter of common assault and pointing of firearm, and here the imprisonment was for 30 days or a fine of 1,500 rand. Then there was another matter where there was an assault GBH, and the matter was not enrolled because at the latter part of the investigation the victim changed his statement about certain aspects of what happened on the assault. Then we have another case which was withdrawn in court, and that's a Mpangeni case, and that's for theft of motor vehicle. Then we have another case that is also withdrawn at court because of insufficient evidence that was leveled against Mr. Sharnick, was common robbery. That's in Richards Bay. We have another matter that was also declined to prosecute. It's a common assault. We have another matter that was resolved through the ADR process, which is an alternative dispute resolution, which was assault GBH and pointing a firearm. We have another matter where he was accused of possession of unlicensed firearm and ammunition, and in that particular matter he was found not guilty for various evidence that was lacking in proving the charge. Then he was also found not guilty on a malicious injury to property docket in the Richards Bay area. He was also found not guilty in another matter for discharging of firearm in a public place in a Richards Bay matter, and he was also found not guilty in the Maiden Wharf matter for the theft of motor vehicle. Why do I reflect on the full history of the cases of Mr. Stuart Sharnick? Because of a statement he made that his reputation and his image is being tarnished. I think we have to reflect on this number of cases, and you look at the cases, both from the vehicle crime cases, and you look at the other cases that involves some form of aggression in terms of allegations against him. So you can see, I'm not sure when we talk about the South African police must defend itself of saying something, because Mr. Stewart has indicated that Lieutenant General Khumalo is the one who is acting on behalf of SAPS, and then he intends to cite SAPS in a civil litigation. So when he says his reputation is being violated, then when I look at this history that I've provided, I'm trying to ask myself, what is factual here about your reputation? How will the South African Police Services be backfooted on what we know about you and the history that you provide us through your interaction with the criminal justice system? And that's the information we have. Now let me address the news of the media. The other two issues that one must reflect on. During the process of profiling Mr. Sharnick, we had to understand there's a number of things that comes up that makes us ask some questions. One of them is this issue of him having a criminal conviction where he says that he's cleared of that. He doesn't have a record, a criminal record. When we look at the criminal record system, I am unfortunately here to tell you that during the month of January this year, we went into the system to do an audit of this part of his information. In our course of doing this preliminary investigation, on the 16th of January at 16:58 in the afternoon of that day, a particular employee of the South African Police Services went into the criminal record system and made some adjustments to the benefit of Mr. Stuart Sharnick. That's why Mr. Sharnick is so confident to say there will be nothing on the system. Unfortunately, the particular employee doesn't understand the full extent of auditing side of the back end of systems. And on the back end of systems, the transactions which he deleted reflects and remains on the back end of the system. Further, we would want to indicate there was some indication that you can apply for an expansion of a conviction, and such expansion then you get an approval and it then can be taken off the system, which is correct. You can, but there are certain provisions and conditions in certain offenses, and the fine cannot exceed a certain amount of money. In his case, it was 150,000 rand as a fine. The threshold was 20,000 rand. So there's no way one would suggest that he could have obtained an expansion of these offenses from his criminal record. It's possible, yes, on some of the assault cases which is older than 10 years and those type of things where there's an option of a fine and no imprisonment, but not on that instance where the fine is higher than 20,000 rand. So those are still there on the back end of the system, which we have discovered. And I want to indicate that the entire forensic side of the system investigation will now be continuing to bring that evidence forward and to hold that employee accountable. Now, of course, we're not sure whether the employee was prompted by somebody or the employee read an expansion of the one case and then thought all the cases should be expanded. We're not sure whether the employee did it intentionally or was it a lack of understanding of what should be done in the system. But when you look at the timelines, it suggests to us that there was something that was done to the preference of this individual. Now, in that process of this entire Madlanga Commission and the comments of Mr. Stuart Sharnick, we also pick up there's this to and fro about whether he's a security officer and whether he's not. That part we can confirm that he is not registered as a security officer. Then you ask yourself certain questions about his profile And when we then start to look at his profile, we pick up Mr. Sharnick owns firearms. In specific, he owns 5 firearms. We ask ourselves a question: how will a person with convictions acquire a firearm license? And for what purpose? When we go into the systems, we then start to understand the process that was unfolding for him to acquire these licenses. I want to take just a minute to unpack these application processes so you understand it. Members of the media, everything I'm speaking of is a summary, and as you can see, this file is still a summary of the extent of dockets. If I had to bring those dockets, they will fill this table up. So when we unpack the system of these 5 firearms, there's 2 processes that you follow when you apply for firearm. The first part is to acquire a competency certificate, which talks to the proficiency of you, how you handle firearms. And once you've passed that stage, you then go into the stage of applying for a license for a firearm. In the first instance, we can say that on the first time he made an application was in 2015. So he made an application, but then he withdrew it in 2015. Made it in February, and then he withdrew that application for a competency certificate. The second time he made an application, again, in Richards Bay, he made an application and it was refused. In that refusal, the reasons for the refusal was failed to disclose previous conviction, failed to disclose outstanding cases. So he had a previous conviction that we picked up on him, and we picked up that he had current cases pending against him in specific 3 cases, which he didn't declare during the time of his application. And then on the third application, where he makes to get a competency certificate again, he then says failed again or refused because you failed to disclose the pending criminal cases. Then he makes a 4th application. In the 4th application, still at Richards Bay, that was made in 2022, he made a 4th application. In that application, it seems that he was, after making the application, we have not gotten the fact on where his movement was, but at the time of that approval, the application is still at Richards Bay for this competency certificate, but his approval is now given to him, and the address on his approval is now showing a address in Gauteng. So that was the competency certificate for the training part. The second part we then discovered is then when you have that certificate, you then have to apply for a license. In that license process of application, his license, his first application of the license he made, which was made in 2023 in February, was approved in July 2023. And that application that he had approved was just for a .338 firearm. The second application he then made in 2023 was refused. Now, you'll work out the reasoning whether it's valid. It says here he was refused on this application where he applied for a handgun because he did not have the prescribed reason to possess as a dedicated person. The third application he made it for a handgun again, which was made in May. And that he got an approval in August of 2023, the same year. And then he made a 4th application where he applied for another rifle, which was then approved in August 2023. And then the 5th application he made for again another rifle, which was made in 2023 on the 5th month and approved on the 8th month. The 6th application he made was in 2023 on the 5th month also, and approved also in the 8th month, was for a shotgun. Now, all these firearms that he applied for, you have to provide reasons. According to our records on the application and the system that it was granted for, it is citing that he applied for these firearms for the purpose of sporting. There's a category in the Firearms Control Act, section 16 of the Firearms Control Act 50 of 2000, which talks to the issue of a categories of applications of license. And in this instance, he applied for a sporting license, a license to possess a firearm for the purpose of sporting. I'm sure by now you would have seen already that is circulating in the media. There is a clip of Mr. Stuart Sharnick in public brandishing a rifle, and the posture and the demeanor suggests that he's a security person in some sort. So one would then realize that sporting is different from being in a security company. There are different provisions, rules that govern it. You have to be registered with PASIRA. You must have a number of compliance issues as a business, your business premises and all that. We are yet to get into that part of the investigation, members of the media, that we are, like I say, this was systems and what we see physically in the dockets here on the case. When it comes to these, we are still going to be looking in the file. What is contained in his motivations? How did he acquire these permits? How did he acquire these licenses with this conviction that he had on him? So that's a process we are still undertaking as we proceed with this particular inquiry that we are making. Now, I want to then indicate also that as part of this particular investigation, and I did say earlier on that I will be making references to or referring certain aspects to both sides of the National Prosecuting Authority as well as the Magistrates Commission, the Judicial Commission. We now note that the addresses also differ on these applications when it comes to firearm from the time of applying. So it's obvious he has moved residence. So we will want to see how and when and what compliance was undertaken by the firearms officer at the particular stations. In this particular instance, we will be reflecting on 2 police stations of interest that handled his firearm applications. The detail I reserve it so that we could allow us to investigate those matters. I indicated the preliminary investigations of the system that we are busy with. Our investigations are going to continue. We are mindful that investigations are complex, especially organized crime investigations, and it takes time, and you will wonder what happens, and you find no responses to what's happening until you find we are now appearing at court with a particular suspect. So those investigations will continue. We are continuing with the investigation on all these aspects, and we will then provide a further detail of these cases. So really, members of the media and the public, the idea of this briefing is to bring context to the South African Police Service, specifically in KwaZulu-Natal, that when we do investigations, we do take it to court. We do rely on what we call PGI investigations, prosecution guided investigations, and we work very closely with the NPA to come to dealing with crime as a collective and addressing criminals as a collective. And so we really will take this matter back to what we've seen in the dockets as to where and how it ended up having 15 serious crimes settled with a sanction of 5 years wholly suspended for lesser offences. I will stop at that. Thank you, Colonel.